Oh, guys, I have a treat for you here on Extra today. I'm here with Massad Ayoob, who, if you don't know who Massad Ayoob is, you have your head in the sand in the defensive firearms world, because I don't think it's too much to say, one of, if not certainly the premier expert on the legal side and the courtroom side of defensive firearms use.
It's kind of you to say that as soon as you start believing that stuff about yourself, you're going to fossilize.
Well, you know, of course, we all have stuff to learn, right? But, do you know how many court cases and how many prosecutions that you've consulted on?
No, I've been doing it since 1979, and I couldn't begin to tell.
So he was doing it when I was 3. He's been calling me kid this weekend, and that maybe holds some water. I love being called kid with all this gray on my beard. It's fantastic.
It's the only revenge we have on you young people that we know are going to live longer.
So I'm going to say this. Max would never say it, but I'm going to say we're 3 days of 4 in. We still have some more to do, and I would say, look, I mean, range stuff is good, and the range portion of MAG-40 is great. The classroom portion, so MAG-20, right? Because that's what MAG-20 is, just the classroom portion.
We separate out the MAG-20 range portion and for people who already feel comfortable with the deadly force training, and the MAG-20 classroom for people who are already comfortable with the shooting skills.
I seriously think, you know me, I'm not going to say the government should mandate. I won't say that. But literally, any and everyone who carries a gun, I think MAG-20 classroom, you should require it of yourself. I mean, I teach this stuff. I have instructor certifications in this stuff, and I'm learning this weekend and seeing things in a new light and hearing the why and the how and understanding how the lawyers look at things and how they talk about it in judges' chambers and in front of a jury, and what is a jury going to hear, and these are the people. I think that kind of thing is just utterly invaluable. And what do you think? I have a few questions about it that I think everybody's excited to hear. In your expert opinion, what do you think is the most misunderstood by most concealed carriers as far as deadly force law?
Wow, that would take longer than you have. But basically, most people tend to focus on the mechanics of it, the draw, the shot, the speed reload, and all that.
The how.
Of course, that's good. You have to have that. But a whole lot of folks figure, well, when the time comes, I'll know.
Oh no.
And that does not turn out to be how it really is. Most training focuses on getting ready to be fighting for your life. And it tends to end after the last shot's been fired, the last piece of grass is dropped away across the sidewalk. That is when the second phase of it begins.
The fight after the fight.
And there are just so many pitfalls there. You have so much bad advice that over the years, it wasn't bad advice from the people who gave it, the defense lawyers who saw their clients getting in trouble by talking about what they had done. And they popularized giving the advice, never talk to the police.
Right.
If you are a guilty criminal, that actually turns out to be remarkably good advice.
If you've murdered someone, don't talk to the police. That's great advice.
The problem of it is, as you know, I've come to call it the false positive. From the first responding officer on, their history, their experience, their training has been whoever's laying there in the puddle of blood is the victim, and whoever's standing there with a smoking gun is the perpetrator. So, first impressions mean things. Now, you're not identified to them. It's not as if they saw you standing there with a police uniform, they know you're one of them, and from the get-go, the assumption is, until proven otherwise, it was a police line of duty shooting that is necessary. You are a suspect. You've just killed somebody, and they don't know who's who or what's what. They don't have a crystal ball. They can't see the halo over your head. So they're going to start basically falling back on their training and their experience. In the past, every genuine intended victim of a crime that they ever interviewed, when they said what happened, the guy said, that SOB tried to kill me, by God, and I'll testify against him in court. And every guilty SOB they ever talked to said, buddy, what's your side? Said, I ain't told you nothing till my mouthpiece gets you. Now, they ask you, buddy, what happened? And you tell them, I'm not telling you anything, my attorney's here. What correlation do they make? The guy laying on the ground was the perpetrator, but because you won the fight, he's doing a very convincing imitation of the victim. And now, by following the conventional wisdom, you're playing along. And that tends to create bad first impressions.
And that rolls the ball, because then those responding officers talk to the investigating officers. They're the ones who talk to the prosecutors. And can it get corrected? Well, sure, it'll get corrected eventually, but you got to spend so much work to correct it.
Not only that, but it's human nature for people not to want to admit they were wrong. And once you've already been arrested, perhaps you've already been charged, you've created a rather uphill fight for your defense team. So that's why for decades now I've been recommending a 5-point checklist. It's turned out to work very well. USCCA has adopted it. Armed Citizens Legal Defense Network has adopted it. Many others. And it's not a script. Okay, never speak to police with a scripted line like, I was in fear for my life. That might have worked 20 years ago. Cops are on it. When they catch, here's a scripted line, they catch somebody who planned for this to happen and is trying to mislead me, and the eyes are just about going to glaze over. So it's a list of things that need to be established. First, we want to establish who's the criminal and who's the victim. The first thing that needs to be said is what I call the active dynamic. Explain not that you shot him. Now, that's going to be kind of self-evident. Explain what he did that made you shoot him. This man came up to my car and put a gun to my head. This man was trying to drag my child into the back of a black belt van. Make it clear that's the perpetrator, you're the intended victim.
Right.
Second, indicate that you will sign a complaint that you will testify against him, words to that effect. Okay, it continues to reestablish you are the victim, thing on ground is the perpetrator.
I'm good guy.
Exactly. Now, saying I'm the good guy is going to create an eye roll.
It is.
But you let them come to their own conclusion by using the language and understanding what their institutional experience has been. Third, point out evidence. Evidence disappears. Now, Ed Morales, the hero of the April 11, 1986 gunfight in Miami, he recently came out with his book, which I would recommend all your viewers and listeners read. The title is FBI Miami Firefight by Ed Morales, M-I-R-E-L-E-S. You can get it from edmorales.com. Ed points out that, among other things, he came very close to being shot by mistake.
Wow.
He was in plain clothes. He's approaching what's obviously an FBI vehicle as responding police officers arrived. Now, those officers, as he put it, all they saw was a large Hispanic land mammal firing a gun into a police car. But the combination of other officers being there, of the positioning, and the good judgment of all those responding Metro Dade officers kept a mistaken identity tragedy from taking place. Now, as far as the evidence side, that was one of the most cataclysmic gunfights in American history, and one of the most complicated crime scenes. There were reports of passers-by and onlookers picking up spent casings as souvenirs of the gunfight. And that stuff goes all the way back to 1934. John Dillinger shot outside the Biograph Theater. Witnesses were coming up and dipping their handkerchiefs in the blood for souvenirs. Ed points out that one of his brother officers, or brother agents, Special Agent Ron Reisner, had fired approximately 24 rounds from his 9mm Smith & Wesson. No more than 7 or 8 of those spent casings were recovered. And the reason was, you had 2 agents dead, you had 3 agents gravely wounded, including Ed Morales himself, and 2 more also wounded. And the priorities were to save life. The prime directive, if you will, of law enforcement, of all public safety personnel, is save life. The medics are trampling the scene. Evidence technicians haven't arrived yet. they're having a flood of officers are having to push back onlookers, and evidence disappeared. And that's going to happen at your scene too. So the third point that I tell my students, point out the evidence before it disappears, the evidence that would have proven your truthful account of the incident. Fourth, point out witnesses. Notoriously, witnesses don't want to get involved. If they leave, you don't know who they are, you don't know where to find them. And their testimony that would have proven your truth of this, if the issue is disputed later, has disappeared with it. So, the five-step sequence, establish the active dynamic of what that person did, and make it in such a way the officer can draw his own conclusion. Who was the victim and who was the perpetrator? Indicate that you'll testify against them, sign a complaint, etc., to confirm it. Point out the evidence, point out the witnesses. The fifth stage, excuse me, at that point is when I would stop answering questions. And I would tell the officers that they'll have my full cooperation after I've spoken with counsel to that point. I have been cooperative, I've established everything I need to establish. The problem with going into detailed questioning of the many things that are going to happen, the officer will ask the questions as they occur to him. Now, there's going to be a blurred line here. You'll be asked questions by many officers. When we speak of the investigating officer, we're talking about the assigned lead investigator. At the same time, from the arrival of the first responding patrol officer, part of their job is to gather intelligence and determine what has happened.
Sure.
So multiple officers will be asking multiple questions. Each of them will ask the questions in the order in which those questions occurred to them. They'll be, if they're not taking notes now, they'll be writing down what they remember of that conversation later. The conversation will be in that order of questions and answers. It will create the false illusion that you gave a narrative of events occurring in exactly that sequence. And later, when you're asked, what was the sequence of events, and you tell them, it's like, wait a minute, these notes by the first officer interviewed say, this happened before this, before this, but now you're saying that happened before that, before that, and it makes you look like a liar. You'll be asked really unanswerable questions. Exactly what words were said. None of us is immune to it.
No.
And if you recall to the best of your ability that it's a couple of words off from what an unseen surveillance camera captured, you are falsely made to look like a liar. You'll be asked, how far away was it? In feet and inches. And virtually no one is able to actually accurately determine that. As we know, one of the things that more often than not occurs in these things is tunnel vision. Now, tunnel vision means we're essentially zooming in on the threat. It's not the eyes doing it like the lens of that camera. It's the brain that's doing it.
Brain's just like, don't care about any of this stuff.
Exactly.
I care about that.
Exactly. The doctors and neuropsychiatrists call it cortical perception. Now, it's actually possible that later, under forensic hypnosis, you might recall things that were on the periphery. But right now, all the brain is recording is we need to focus on this thing trying to kill us.
Sure.
Now, all our lives, we've determined the size of something or the distance of something by how it appears to us vis-a-vis its background. Now, it's as if your eyes were let's say, a semi-wide angle lens on a camera with normal vision. If someone just turned on a 400, 600 millimeter telephone,
right,
it totally alters the perspective. It makes them appear larger than they are, it makes them appear closer than they are. And when you say, yeah, the guy was only, well, since you asked officer, he was about 6'3", how far was with him? I'd say 3 feet. And the unseen surveillance camera showed, no, he was only my height, and he was 3 yards away instead of 3 feet away. It looks to the world as if you're a liar. I tell the investigators, never ask unanswerable questions. It's not only unfair to the person you're questioning, it ill serves the truth of the investigation. And I tell those who are going to be questioned, you can't give a detailed answer. It's not within the realm of reasonable human expectation.
Well, and then having given those 4 things, they can start their objective investigation. And then you say, I want to cooperate fully, but I need to speak to counsel.
Exactly.
And your counsel is going to say, he needs to get away from this a little bit before he makes a statement. He's going to say, hey, he's going to need to sleep or whatever, just like police officers get before they make a statement. You said something interesting there that I want to ask about, because one of the big things that I've learned this weekend is words matter. And the way we articulate things matters a great deal. And you said, officer, I'm going to cooperate fully, but first I need to speak with counsel. Now, you did not say, but I got to talk to my attorney. Do you think
Same difference.
Same thing? You don't care about that
Same
one? That's
difference.
okay?
What you do have to bear in mind, based on current case law, you really do have to request counsel.
So,
Invoke your right to remain silent.
To
One thing,
invoke
by
the
way,
right.
Don't say, I'm invoking my Fifth Amendment rights. Okay, that is, Fifth Amendment says basically you're not required to say anything that would incriminate you.
Right.
When you invoke Fifth Amendment, ipso facto, you're saying anything I say will incriminate me. And the general public sees that as guilty. If you set it on camera or it's recorded in the officer's notes, it may come in, and if it does, it will create that impression. Simply say indicate that they will have your full cooperation, but you wish to speak to your attorney first.
Well, and that's, you have, is enumerated in the Miranda warning, right? You have the right to an attorney. You have the right to counsel. And if you assert that right, then they have to respect that. And I don't know any cop who doesn't want to respect that right. They want to, because you're doing the things that establish you as the victim. So once I've established that, then they want that. These are the kind of things you learn in the classroom portion of MAG-40, the reason you want to be there. But there's more than that here. It's about understanding criminal mentality, understanding how you have to respond to that, and deal with the difference between using your firearm and maybe taking someone at gunpoint. And these kind of things, I think, are misconstrued on the internet so bad. And they're misconstrued so bad, I'm not going to put them on a YouTube video for you to misconstrue and take out of context. I'm going to tell you to take the class. So, yeah, and I think, man, having read it, your latest book, Deadly Force, is another killer resource, bad word, incredible resource for that. What made you want to kind of put, because you got several other books that cover a lot of the same thing.
I had written Gravest Extreme in the 1970s, and it came out in 1980. And it's still selling well. It's not that I was a great writer, it's simply that Deadly Force Law is one of the most mature bodies of law that we have. There were things that needed to be updated, issues of castle doctrine, stand your ground, that have, particularly in the last 5 years, become widely misunderstood, misinterpreted by everyone, from the newspaper pundits to the politicians themselves, and certainly the gun prohibitions.
I think as well, there's another myth that I think I'd love to talk about briefly, is the myth that if you, as a good person, are involved in a deadly force encounter, you have to use your firearm, then you won't have to testify in court.
Well, first, in a civil suit, actually you can be compelled to testify. In the criminal case, you're not required to, but you definitely want to. The reason that, so many defense attorneys say, I never put my client on the stand, is that so many of their clients are guilty, and there's nothing they can say on the stand without inculpating themselves or making things worse and lying, and going up the river for an additional time for perjury, which is a felony in every jurisdiction I know of, and creating the very real possibility in everyone's mind that the attorney told them to lie on the stand or knew they were going to, which
send the attorney to jail.
Is subornation of perjury, which in my state is a class 4 felony, and in any state will cost you your bar ticket.
Yeah.
So of course the attorneys tell them, we're not putting you on the stand. What you've got with self-defense, John, is an affirmative defense. You're not saying I didn't do it. You're saying, yeah, I shot it. I was right to shoot it. In real-world trial strategy, real-world jury psychology, that shifts the burden of proof to the defendant. The defendant's going to have to show the triers of the facts that they did, in fact, have to shoot him in self-defense. to essentially a preponderance of evidence. This means what it's come down to is not who done it.
We know who done it.
Yeah, it's come down to why'd you do it.
Hmm.
And in that situation, there's only one person who can truly fully answer that, and that is you, the person who pulled the trigger.
And I think that's why taking classes like MAG-40, and I think particularly MAG-40, gives you a preparation for that says, listen, I'm going to have to articulate these things so that I have a good understanding of these are the tools that I carry and why, because that could get questioned. This is what fear I was in is reasonable for this reason. This is what I experienced in that moment. And here are the things that I'm going to avoid saying, and that I'm going to be talking with my attorney when the expert witness comes in, and to say this is what happened. To be prepared for all of that emotionally, mentally, spiritually, I think is incredibly important. And I think if you're carrying a firearm and you're not ready for those things, I think that you're doing yourself a grave disservice. So where are people going to find more classes?
With us, your best bet is our website at massadayoob.com, MASSADAYOOB.com. We teach around the country. We have something within reasonable striking distance of almost everyone in the lower 48.
Yeah, it was reasonable striking distance to come from Phoenix to Nebraska. I mean, Lincoln, Nebraska is just a short jaunt, but you can probably find one closer. I was joking.
It's not my fault you missed Tucson.
It's true. Last February, he was in Tucson, and I was in Thailand at the time, of course. So, man, I just appreciate your wisdom. I appreciate your kindness, that you approach this from the perspective not of, I'm the guru on the mountain, but that I'm your guide here. Let me help you on this journey.
I'm the funnel who brings it to you. I'm not the fountain of knowledge. I'm just the funnel that gathers it and brings it to you.
And I appreciate that I feel like this has helped me. And I told this to Gail a little bit ago that I probably had 90% of this material from my other studies and reading you and these other ones, but having it put together has been incredible. So, Mass, thank you so much. I appreciate the work you do.
I appreciate all you've done and all that you do for your listeners.